I'm David Parker. I'm an estate planning and elder law attorney, and I'm going to be talking to you about how to do probate yourself. Now, some people feel that they'd rather do the probate themselves. They don't want to deal with an attorney, so I'm going to try to walk you through some of the process, and then you can decide whether it's something you want to do or hire an attorney to do it. One thing I'll mention, though, is that you don't have to use the attorney that created the will in order to do probate. Any attorney can probate any will, and we're happy to take a look at it and help you out with it. And we can do it in any county in New York State. So, just like doing a simple taxes, a person can do a simple probate, usually without an attorney. So how do you do it? Well, first of all, you have to figure out where the person was domiciled. That means where they were living at the time that they passed away. Could be their home, could be the nursing home. You have to figure out what state they were in at that time, and that's the state you're going to probate the estate. You also then have to figure out which county. Now, one thing I'm going to mention is I'm a New York attorney. These are New York rules. We're going to be talking about New York. Every state has its own set of rules. So once we've determined that we're going to do this in New York State, the next thing we do is figure out what county we're going to use. And one thing I will mention also, if you have property in another state, even though the person was living in New York State, they have to do a New York probate, but let's say they owned a house in the Poconos, or they owned a house down in Florida, you're going to have to go out and do the same probate process in that other state. You cannot probate real property that's not in New York. You have to go to the other state. So if the person had a house here in New York and a house down in Florida, you're going to have to do two sets of probates. So once you figure out what county you're working with, then you have to figure out, is there a will? Okay, so go out and find the will. Now, if you find the will, you also have to make sure it hasn't been damaged or destroyed. And what is damaged or destroyed? If mom or dad crossed out some paragraphs because they were angry with somebody and didn't want to give one of the kids some money and they hand wrote on the side, you've got a problem with that will. But the most common mistake I see, the will is always stapled with a big fancy back. And so what happens is, if you remove the staples because you wanted to make a photocopy, you now have a damaged will, and you're going to have some issues with that. If you can't find the will, or you find a copy that's not signed, generally that means that the attorney who wrote it up has the copy of the will. Just write to the attorney, ask them for a copy. As I said, you can use any attorney to get the will or probate the will. You can use that attorney or another attorney. Just get a copy of the will from the attorney that wrote it up. Usually means they're holding it in their safe. We attorneys like to hold the wills because, frankly, we want you to call us when something happens. So, if you can't find a will, you go through what's called an administration proceeding. All the things I'm going to describe to you are pretty much the same, but you're going to do what's called an administration proceeding instead of a probate proceeding. Process is largely the same, you're just doing it under another section of the statute, means you can't find the will. So, you go down to the surrogates court. That's the court that handles wills and trusts and all these type of issues. You go down to the surrogates court in that county and ask them for the forms to file a probate petition. Once you fill out the information on the probate petition, and the forms can be a little confusing, the clerks can help you to a certain extent, but they can't practice law, so they can't give you all the answers. The main thing you have to figure out is who are the distributees. That's the heirs under the estate, and that's contained in the estate powers and trust law, how to figure that out. You figure out who the heirs are. The main thing to understand, though, is that if you have, say, a sibling who was cut out of the will, or a child who was cut out of the will, what's going to happen is you have to notify them that this proceeding is going on. Even if they're removed from the will, you still have to give them a notification. So all the distributees have to be notified of the proceeding. Now, you're going to propose yourself as executor if you're filling out the form, or whatever the will states, you follow the will. The people who are named executors will file and say, I wish to become the executor of this estate, and given power and control to take over the assets and distribute them according to the will. And you notify all the distributees of what's going on. You have to give them an opportunity to come into court and contest the appointment. After that time period goes by, you get what's called letters testamentary, or letters of administration in an administration proceeding. And what those letters state is that it says this person has the lawful legal authority to take control of the estate. Then you go out to the banks, to the brokerage firms, you take control of the accounts, you figure out what you're going to do with all the assets. First you collect all the assets, and then you fill out what's called an inventory of assets. And you write down a list of all the assets. You have to submit that to the court. If any estate taxes are due, you have to file an estate tax form. And remember, New York State has $1 million exemption. The feds have a $5 million exemption. This is in 2011. But New York State has $1 million exemption. So if the person who passed away has more than $1 million in assets, you have to file a New York State estate tax return. Now, you pay off all the debts, you pay off all the expenses of the decedent, you do whatever you're going to do with the property, either liquidate it or turn it over to relatives, etc., however you're going to do it, and then you report back to the court. Now, if you have property, if you have businesses, you're going to have to get an appraisal for those assets. Obviously, when you're writing down the value of a bank account, you just take the statement, write down the value. Brokerage account, you write down that month's value. But if it's a piece of property, if it's a business, if it's an expensive heirloom, you're going to have to get an appraisal because you can't just write a number in there. It has to be justified or backed up. So you file that list of assets and inventory with the court with the appraised values. You pay off all the debts and all the expenses. Then you distribute all the assets according to the terms of the will. After that's all done, you make a final report to the court, and then you've completed the probate. I hope this was helpful in explaining how this is done. If you're still confused or you want to have an attorney handle it, please feel free to give my office a call, and we'll handle probate. We do it in any state in New York State.